to our practice. So today we'll be handling a panel of three. I call them a panel of three chairs. So in no particular order, members, allow me to also welcome them as I introduce them. The first, I'll use the ladies first rule. It is a rule that is allowed and accepted widely. So on the panel today is Caroline Mboku. Caroline is an advocate of the High Court of Kenya with 12 years experience and practice in the name and style of Mboku and Company Advocates. She's a certified professional mediator with the Mediation Training Institute in East Africa. She has also just completed her secretarial course, company secretary course with CASNEB, and enrolled for Masters of Law at Cincinnati University in the USA. Caroline is a human rights defender. She uses her voice to not only advocate for human rights, but to also encourage, empower, mentor women and the youth. She's passionate about positioning women's voices in public issues and is an active member of various non-governmental and community-based organizations where she has taken leadership roles, including but not limited to being the vice chair in the executive committee of the Mombasa branch Young Women Christian Association. She's an immediate and past board member in the governing council of FIDA, which is a women's rights organization that conducts research on matters affecting women, trains women on leadership and good governance, and assists women and children to access justice through free legal representation. Caroline is the chairperson of the HIV/AIDS Tribunal in Kenya, which is a quasi judicial court established to hear and determine cases of violations of rights of people living with HIV and AIDS in Kenya, and is a member of the National Committee on Criminal Justice Reforms, a committee that spearheads comprehensive review and reform of the Kenyan criminal justice system. She is the board secretary of Hazina Development Trust Limited, which offers zero-rated interest loans to women and youth within the coast regions, and is an immediate past, she's a past vice chair in the Mombasa Law Society Welfare Association. Miss Caroline, if you can hear me, and just like me, let me just also put on my camera so that members can see me. Please just say hello to members, and just anything you want to say and add to that.
Good afternoon, members. I'm happy to be joining you from the coastal city of Mombasa, and thank you for the invites. I hope we shall interact more as you get to know about the tribunal that I chair. I'm looking forward to the session. Thank you.
Thank you very much. I was wondering why you're dressed opposite to how we are dressed. We are joining us from the coastal city. Karibu sana. Next on that panel is one of our known Mheshimiwa, I call him Honorable Benard Choi. He's the chairman of Water Tribunal. He's also the chief magistrate Milimani Law Courts and the chairman of KMJA Nairobi region. That will be Kenya Magistrate Judges Association. He's an advocate of the High Court of Kenya. He holds an LLB degree from Bamu University in India and his postgraduate diploma from Kenya School of Law. He is currently pursuing his master's in peace and conflict resolution. Wow. He has practiced law previously for 7 years as an associate with the firm of Murungi and Company before being admitted to the bench in 2005. Since 2005, he has worked in several stations, including Maua Law Courts in Meru, Kibra Law Courts, Wanguru Law Courts in Kirinyaga, Siaya Law Courts, and Mukurweini Law Courts. And he's been the head of station in the last three. That is Mukurweini, Siaya, and Wanguru. While at Milimani Law Courts, he occasionally serves as a judge advocate in court martial at Kahawa Barracks, Langata Barracks, and Eastleigh Barracks. From 2nd September 2024, he will be proceeding to head the Children's Court in Nairobi. Over the past 25 years practice in the legal profession, he has been passionate about conflict resolution. Mr. Choi is a lover of sport and the captain of Mahakama FC Football Club. I don't know why, Hesh, we have not seen you play football, but welcome. Thank you for joining us. Your microphone is on mute. Please, you can just unmute and say hello to members.
Okay, good afternoon, everyone. Thank you for the invitation. I'm also glad to be here. I'm sure that we have interacted with some of you, either in the criminal courts or some in the water tribunal. So I'm excited to be around as we share this session of knowing the tribunal. Welcome, and I'm glad to be around. Thank you.
Thank you very much. Thank you very much. Last but not least, is one of our lecturers. I call him one of my favorite lecturers, Dr. Kenneth Wyne Mutuma. Dr. Kenneth Wyne Mutuma is an advocate of the High Court of Kenya and has been in practice for the last 24 years. He is presently a partner at the firm of Wyne and Associates Advocates. Dr. Wyne holds several academic qualifications, including a doctorate and a master's in law from the University of Cape Town, as well as an undergraduate degree from the University of Liverpool. He's a qualified architect, having graduated with a bachelor's degree in architecture from the University of Nairobi. His practice spans a wide range of areas, including commercial law, commercial arbitration, construction adjudication, mediation, litigation, conveyancing, corporate governance, and international law. Dr. Kenneth is a fellow, certified secretary, chartered arbitrator of the Chartered Institute of Arbitrators, London, a certified professional mediator, a certified governance auditor. He's an active member of the Institute of Certified Secretaries, Chartered Institute of Arbitrators, Kenya, Law Society of Kenya, Architectural Association of Kenya, and the East African Law Society, the Nairobi Center for International Arbitration, the International Chamber of Commerce, the Kigali International Arbitration Center, the Dispute Resolution Panel of the Architectural Association of Kenya, and the International Commission of Jurists. He has a comprehensive understanding of ADR processes, having acted as an arbitrator, adjudicator, and mediator in a wide range of commercial and construction disputes. Dr. Wyne possesses accumulated experience in academic leadership around international law, ADR, corporate governance. He is currently a senior lecturer at the University of Nairobi, where he teaches public international law, international relations, human rights law, international humanitarian law, and ADR at the undergraduate, master's, and doctoral levels. He has published extensively in these subjects, both locally and internationally, in the form of books, book chapters, and peer-reviewed journals. He has also authored several publications on corporate governance, international law, and ADR, and he serves as an editor-in-chief in a number of journals. In addition, he has undertaken several consultancies across the continent in these areas. Dr. Wyne has extensive senior management experience across local and international settings, as well as practical knowledge in interdisciplinary issues. He has and continues to serve as legal advisor to a range of international government and corporate entities working to address various developmental challenges. Part of his accomplishments relate to the role he played as a regional legal advisor for the International Committee of Tribunals, his role as legal officer at the United Nations High Commission for Refugees, his engagement to the South African National Assembly as a legal coordinator, and his work implementing national capacity development program on behalf of the Nelson Mandela Foundation. He's a member of several boards in the public, private, and non-profit spheres, and has been part of a team attached to the State Corporations Advisory Committee that is working to strengthen the capacity of national state corporation boards. I thought that at some point I could rest and just continue with that introduction. Welcome, Mr. Kenneth Wyne Mutuma.
And like Carol, I'm in a very, very cold place. Please forgive my dress code. I'm joining from the tip of the continent, and it's been very, very cold on the side. Thank you very much. I'm honored and privileged to be here. Asante.
Thank you very much, Mwalimu. I looked at your introduction. I thought I would see that you are also part of the disciplinary advocates disciplinary committee, something. I think we did a vote.
Yes, which is an old profile. I will add that very significant term events. Asante sana, Sheila.
Karibu sana.
Yes, not in the classroom. Vizuri kuona hapa mahali tupo. Asante.
Okay, welcome. Feel at home. Having elected you, I know majority of the members have their vote of confidence in you, so feel very welcome. Thank you as well, colleagues, for making time to just join our session today as we learn about our tribunals. I will now take us directly into the session, where again I want to begin with Ms. Mboku. Ms. Mboku, as you bring us into HIV and AIDS Tribunal, briefly tell us what is it composed of and what kind of cases does it handle?
Okay. Thank you so much, Effie. I hope everyone can hear me.
Yes, we can, loud and clear.
Okay, thank you. Yes. Every time I talk about the HIV and AIDS Tribunal, I ask people who have heard of it or interacted with the tribunal, and most of the time the answer I get is usually in the negative. However, this is a tribunal that has been in existence since 2011, and it is a tribunal that was established simply to cater for the human rights of people that are dealing with HIV and AIDS. And it is created under a statute, and that is the HIV and AIDS Prevention and Control Act of 2006 that came into effect in 2011. It is comprised of a chairperson who is an advocate of the High Court of Kenya of 7 years standing, and I represent that seat. And then we have two advocates who are supposed to have practiced for not less than 5 years. And then we have two doctors. In that capacity, I have Honorable Brian Yogo from Nakuru and Honorable Nelson Osiemo from Nairobi. And then we have two doctors who are practicing doctors. Under that, we have Professor Walter Zaoko and Dr. Irene Mukui. And then we have two professionals who have an idea of the HIV space. And under that docket, we have Honorable Jane Goiri and Dr. Solomon Musani. And so this is a tribunal that is made up of 3 advocates and 4 experts. Thank you.
So, Carol, apart from the composition of the tribunal, roughly what kind of cases does it handle? Okay. What manner of cases does it handle?
We have 3 categories of cases that we handle. The first category is safe practices and procedures in hospitals, where according to the Act, there are laid down, there are laws that have been set under the HIV/AIDS Prevention and Control Act. And some of these laws actually affect hospitals. For instance, one of the things we're looking at is safe practices in hospital, where once someone goes to hospital to do a HIV and AIDS, a HIV test, they're supposed to be cancelled. That is before the test and after the test. So should someone go to hospital and they're not cancelled either prior or after the test, then that is a violation under the Act. And then it also prohibits against compulsory testing, where you go to a hospital and the doctor just decides to test you. So you have to give consent before you are tested. And then and the consent, we also look at how the consent was obtained. Did you give informed consent, or they just told you sign? They give you a document and just tell you sign here. So those are some of the practices that we are looking at. And then when it comes to testing, again, it also prohibits the hospitals from testing someone compulsorily, simply because they are going for a job interview and a HIV test is required, or people who want to get married or travel out of the country. So the issue of consent really comes about when we are dealing with hospitals. Then apart from when we're also dealing with hospitals, we're also looking at the issue of the disclosure, how your results are disclosed to you. Is it in a private setting? Was it in the company of other people? And did you give your consent for your results to be shared with third parties? So those are some of the factors that we are looking at when we look at hospitals. Then apart from that, the other issues that we look at are confidentiality and disclosure of HIV status to third parties. Ideally, a bulk of our cases fall under the issue of confidentiality, where here at the Coast region, we say watu wanapenda umbea. Umbea is moshene, where someone just decides to either malign your name and say that I know so-and-so is HIV positive, or for sure they know that you are positive and they decide to tell it to third parties. So according to the Act, you're not supposed to disclose someone's status unless there's written consent by the person who is HIV positive for the status to be shared. So a bulk of the matters that we handle actually fall under this region, or where we see family members, friends, and we've also seen cases where the disclosure is made in public spaces like social media, where someone just puts your photo there and says that this lady or this guy is spreading HIV throughout. So those are some of the cases that we deal with. And then finally, we deal with cases of the discrimination and discrimination and practices. And here we have seen employers who have been brought to the tribunal simply because they have forced their employees to undertake the test, or simply because you have been denied a job, basically, for having tested positive. Or in instances, we've also seen cases in schools where children have been denied access to school simply because they're taking medication, or they've been denied access to take their medication. And then also public service, where assuming you want to take a public office and you turn out to be positive, and people know your status, and then you're denied a public position simply because of your status. And then again, here we also deal with matters insurance, where some insurance refuse to give insurance covers based on someone's HIV status. But of course, under the issue of insurance, there is an exception where the insurance are usually advised to put a cap, such that if they say the maximum they can pay is 3 million, then if you want an insurance cover that is more than 3 million, then they're allowed, as long as they're allowed to enhance the policy. I mean, to enhance the amount so that you can get the policy. But so in summary, those are the 3 areas that we deal with.
Very well. That's a very wide and comprehensive introduction of what the tribunal does. I know members have a lot of questions, and I'd like to just inform them that their questions can be put in the chat section, and then at every break, we'll be taking a few questions and as we proceed.
Okay.
So thank you, Ms. Mboku. Allow me to also bring in Mr. Kenneth Wyne. You know whether you have a stable connection and you can hear us.
Yes, I can hear you very clearly. I hope you can hear me. I might put off my video so that my network, my bandwidth holds together. Yes, back to you, Sheila.
Very well. We can hear you. Just kindly turn on your volume slightly and take us through the National Examination Appeals Tribunal. What is the composition? What do you do? And how can I approach that tribunal as a member of the profession?
All right. Let me just confirm that you're able to see very quickly on the screen before you. I'll try and be very, very brief. Sheila, you let me know if I'm not coming out loud and clear, and then I will project my voice even more. So the tribunal is pursuant to the Kenya National Examination Council Act. And the idea behind this act, of course, is the integrity of the exam process. You'll all remember those stories that we had in the media. Former CS, when he was in charge of this docket, spoke a lot about integrity. And so education is about learning, but more important, it's about whether that learning can be assessed in a manner that has integrity. So the act comes about into play to beef up that area of examinations. And we sit somewhere within the context of that act in section 40B. So you'll see our composition is very much like other tribunals. Our 5 members, and you can see the qualifications of different members when you go into the act. You'll see representations from learning institutions, teaching faculty, TVETs, and so forth, and the same kind of qualifications for the chair in line with Chapter 6 and the other members in line with Chapter 6 and so forth. The tenure again is very similar in line with good governance. The 4 years for the chair, 3 years for the other members. We are the newest. We're not as old as my sister's tribunal. Its tribunal has been there for a while. We are only 6 months old, and we still are under very, very rigorous timelines, particularly during exam period. Just post the exam period, when exams are released, and then the pressure and the crunch starts to hit on the tribunal. The mandate is very, very clear and straightforward. If you recall, this situation, when several exams had been cancelled, that was around 2014, there was so much that was happening during that period. And that is where the mandate actually comes from. We are to address specifically questions around the withholding or the cancellation of results by the council. So there's an appeal process, and our jurisdiction sits with that appeal process. And that appeal can be by an individual through county directors of education. It can be directly by the institutions to us. And we then deliberate over the actions of the council and make a determination. I think in terms of an introduction, Sheila, that would give you a quick overview. Thank you.
Thank you, Chair. So apart from introduction and the kind of cases that you handle, how would I, as an advocate, approach the tribunal to file a case?
Okay, so the tribunal is very user-friendly. In fact, we do encourage the users, that those are the educational institutions and so forth, to actually come directly to us. The thinking is Article 159 of the Constitution, where we are trying to more and more make sure there's an interface between tribunals and actual users of the product. So this is one area we encourage advocates to put on their hats of public interest litigation, where It's not necessarily lucrative for what you call pecuniary gains, but more in the range of the service that we'd actually give to the public. The procedure is very, very direct. It's like all other tribunals. You file a complaint and you lodge the complaint directly with us. We have a secretariat that is in the ministry, but is slowly being moved to the judiciary. Initially, it was thought that the ministry would act as a secretariat, but obviously because of the conflict of interest, many of these tribunals now are moving their secretariats to the judiciary. And you will see that we have an office and an email where this, I think it is on the website, where one can actually file directly when you are lending support to a party. There are no over technicalities that we impose on the process. In fact, you'll see prescribed forms right there under the Act, and simply how to load those forms somewhere on the Bingo Street at the moment. The current email that we're using, the education appeals, and so forth. Beyond that, I think the procedure is very similar to what advocates are acquainted with when you're dealing with a complaint and the sequence of upon which you put forward your pleadings, the way you, of course, submit. We don't have oral hearings. Most of what we do is dependent on documentary submissions. And then, of course, each of these stages then culminates with submissions upon which the tribunal then makes a determination. So there's an email. If you go to the website, educationappealstribunal@gmail.com, that can be of great assistance to our colleagues when they come across matters, particularly in the public domain, where there have been cancellations or nullification of results. Thank you, Sheila.
Thank you so much, Mr. Kenneth Mutuma, for that very in-depth introduction and for sharing that email. I hope Secretariat will be sharing the email in the chat section. I've also noted it down. I will share with my colleagues in other spheres. So, Mr. Choi. Thank you. I see the email has been shared. Mr. Choi, please introduce us to the Water Tribunal. What is it composed of? How are your cases looking like? Water Tribunal is, I think, is a new tribunal to most of us.
Yes.
We've not heard about it, or we've not interacted with it. So just take us through how it looks like. What cases do you do? I think you've hung. We can't hear you. Mr. Choi, I don't know whether you can hear me. Can you hear me, sir?
Sorry, I'm sorry. I think just a few small hitch. So you can hear me now?
Yes, we can.
Okay, so thank you, Sheila. So before I go to the composition of the tribunal, you have said that the Water Tribunal is a fairly new tribunal. So I want to give just a brief history. Actually, the Water Tribunal is not it is not very new, but it is a transition. The Water Tribunal is a transition from the Water Appeals Board, which was established in the year 2007. So it is not very new, but so I'll just give a brief background so that members may be able to understand where we are coming from. So the Water Appeals Board actually had been established in 2007 under the Water Act of 2002, and the mandate under the Water Act of 2002 was to hear and determine disputes within the water sector. With the alignment of the water sector to the Constitution of Kenya 2010, the Water Act was amended in the year 2016. And the new Water Act of 2016 created the Water Tribunal. The new Act 2016 created now the Water Tribunal. However, there was a challenge in the transition from the Water Appeals Board to the Water Tribunal, and this actually took a very long period than expected. It actually took almost 7 years for the transition to take place. And for those 7 years, the Water Appeals Board actually never sat and never did or hear any matters. And the main challenge actually in transiting to the Water Tribunal was due to existence of a lacuna in the Water Act of 2016. And this challenge actually, this lacuna posed a challenge to operationalizing the Water Tribunal. The main challenge was that the Water Act of 2016 did not provide for the appointment of members. It provided for appointment of the chair, Water Tribunal, but there was no provision for appointment of members to the tribunal. And this was contrary to what was the situation prevailing there before in the Water Appeals Board, which had the chair and the 3 other members. So for a long time, there was debate whether the chair could sit alone in the Water Tribunal, but some guidance was given from the Solicitor General's office to the effect that there is nothing in the Constitution or in the Act that barred the chair from proceeding to hear matters pending the appointment or the amendment of the Water Act. And that is how I was appointed to be chair of the Water Tribunal. And the tribunal was operationalized. Actually, it was operationalized on the 30th of December 2022, vide Lego Notice number 255 and 256 by the Cabinet Secretary, Water, Sanitation and Irrigation. The tribunal was previously at the Ministry of Water, as a department in the Ministry of Water, but the same was transitioned. It transitioned to the judiciary, and this was done on 18th of July 2023, when the then Minister for Water and Sanitation handed over the tribunal to the Chief Justice, to the judiciary at the Supreme Court building. So as I have said now, there is actually a bill that is in Parliament for amendment of the Water Act 2016, so that there can include members. The bill proposes membership 6 members, but for now, I'm the only person who is sitting as the chair, and hear matters according to the Act. the qualifications for appointment of the chair of the tribunal are the same qualifications for appointment of a judge to the High Court. So at the moment, I sit alone, and most of our matters, we do them virtually, but we have a secretariat. I think most of you are aware that the tribunals, normally we have what we call shared services. We have a secretariat at Kenya Re Towers in Upper Hill. That is where the secretariat is. And we deal, and we, at the secretariat, that's where we file our matters. But cases are normally filed through the portal. We're in the e-system, the judiciary portal, and matters are filed through the e-filing system portal. So I think I'll now go to the jurisdiction of the Water Tribunal, the nature of cases. So as I'd indicated previously, this tribunal was called the Water Appeals Board. And maybe someone could ask, why was it called the Appeals Board? The reason basically is that the tribunal hears both, it hears appeals, and also has the original jurisdiction. And in most cases previously were in the nature of appeals. And the appeals, okay, let me just start by stating first on the issue of appeals before going to now the original jurisdiction. So the tribunal has the mandate to hear appeals either from any person or an institution directly affected by decisions that are made by the cabinet secretary for water in relation to water issues, or the authority. And the authority herein, I mean the water resources authority, and also from the water resources, for water services regulatory board. So the water services regulatory board deals with water service providers. So we are aware that each county has water service providers. For instance, in Nairobi, we have Nairobi City Water and Sewerage Company. Machakos, I think there's Mavoko Water Services. Nakuru, all these counties, I think, but all these counties have water service providers. So the Water Services Regulatory Board deals with issues issues dealing with the water services, the water service companies, while the Water Resources Authority deals with the issues of licensing. Because you know, all these water service providers apply for licenses. There are certain conditions which they have to meet before licenses are issued. And these are issues that are dealt with the Water Resources Authority, where there are people or the applicants, the water service providers, are not satisfied with the decisions that are made by the water services, the Water Services Regulatory Board or Water Resources Authority, then they file appeals. So they file appeals against the decision of the regulators. And that is why, that is how now the appellate jurisdiction comes in. On the other hand, the tribunal also hears and determines disputes concerning water resources or water services, where there is a business contract. And I can give examples. In this case, disputes between the water service providers and the water users. So the water users, for instance, is someone who has applied for water, and you have a dispute with the water service provider. And in most cases, the common cases here are the billing disputes. So in fact, most of our cases in the tribunal are basically cases dealing with the billing disputes between the water service providers, that is the water service provider companies, and the consumers of water concerning disputes. We'll note that before water is supplied to anyone, you have to, there is a contract that is entered between the water service provider, that is the company, and the consumer of water, the one who applies for water. So that is why we say that we hear and determine disputes concerning water resources or water services where there is a business contract. So the contract is that the water consumer will pay for the water consumed, which is defined by the bill that is presented. And then the water service provider is supposed to provide clean water to the consumers. So that is basically our jurisdiction. There are appeals from the water tribunal are normally filed to the Environment and Land Court. So any appeal from our tribunal is filed to the Environment and Land Court, and the period is within 30 days of a judgment being given. So I think as a part of introduction, that's all I can say for now.
Thank you very much,
Yes.
Mr. Choi. I think there are a number of questions, and because you are the last, I'll just let you deal with the question.
Yes. Mm-hmm.
Mr. Ndirangu asks,
Yes.
is the jurisdiction of the water tribunal equivalent to that of the High Court? That's the first question. The secondly is that what kind of cases does the water tribunal handle? I think you have touched a bit about that.
Yeah. So I think I've actually touched a bit on that. The kind of the main the most cases that we handle basically are disputes between the water service providers, the companies, and the water consumers, through the bills that are presented. So normally you find people disputing the bills that have been given. So those are the most cases that we deal with. But as I've said, there are also cases where water service providers are applying, for instance, for licenses to supply water. And you find that maybe the regulators, the Water Services Regulatory Board or the Water Resources Authority, they deny to give the licenses. So they will file appeals to the board, and to the tribunal, and the tribunal will give now decisions. As regarding the question whether the jurisdiction is the same as that of the High Court, I think it is not the same, as I've said. The jurisdiction of the High Court, in this case, I've said the Environment and Land Court, they will not hear these matters at the initial stage. They will only entertain appeals from the Water Tribunal. So what has been happening is that, as I said, there was a long time before, after the enactment of the new act, the 2016 Water Act, there was a long period of 7 years when the Water Appeals Board was not sitting. So there was quite some confusion at that time as to where parties, the people who had issues, these water disputes, where they would file their matters. So what happened is that many people found themselves filing matters in some in the lower courts, in the lower courts. Others went to the High Court, Environment and Land Court. But at that time, it was because the Water Tribunal, or the Water Appeals Board for that matter, it was not operational for a period of actually almost 7 years. But after the tribunal was operationalized, all those matters, many matters have been sent from these courts, the civil courts, some even from the Environment and Land Court, have been referred back to the tribunal for determination as the one with original jurisdiction for determination before they could go to the Environment and Land Court. So I think that's it for now. Thank you.
Thank you so much. Very well. And
Yeah.
I see there are a number of questions, and somebody has also raised his hand.
Yes, yes. Maybe we can take one again before we go to the others.
Yeah, yes. One further question is,
Mm-hmm.
how about, Priscilla is asking, how about the cases where water providers go for months on end without providing water despite requests by residents? Where can they go for assistance?
Where the water, there is an application for, you have made applications for water, but the same is not
The providers are not bringing, they're not availing water for months.
Yeah, so in that case, water, in that case, the first thing is you write to the water resources, you know, that is a water resource. So you write to the water resources authority. So you can do a letter to them and file that complaint. So once you file that complaint, they whatever decision that they are going to make, if the same is not maybe appropriate, or you don't feel that they have handled your matter as you require, or they are not provided the water, then you can come to the water tribunal.
Very well. Thank you so much.
Yes.
Allow me then to bring in again Ms. Mboku. Ms. Mboku, there are two questions. I don't know whether you have seen them from the chat section, or I can read them out.
Yes, I have, but perhaps you can just read them out for the benefit of those who have not read.
Very well. Priscilla Nduta again asks that we see there are cases where marriage officers refuse to officiate a wedding since the parties have refused to undergo a HIV test. Where do you classify this? Then she asks again, is it compulsory testing? That is number one. Then the other question is Ruth Kibebo asking, some clients complain of a deliberate HIV transmission. How do you handle such a case, and what is the evidence that a man X has infected a female S?
Okay.
So I think she's asking, how do you classify, how do you handle a case where somebody has infected somebody?
Yeah. So I'll start with Priscilla's question. And yes, Priscilla, you asked a question and went ahead to answer it. For where you have been forced to test, and then either by the priest or by your employer, that is an offense, and under Section 13 of the HIV/AIDS Prevention and Control Act, because it outlaws forceful testing or compulsory testing for purposes of either marriage, employment, getting admission in schools, or for purposes of insurance, where there is no exception to that rule. And so that one falls under compulsory testing, and we handle such cases. So if you have a client who has such a similar case, you can approach us, and we shall deal with it. Then I will also tackle Ruth's question. Now, we used to have Section 24 of the HIV and AIDS Prevention and Control Act, which provided for willful infections. However, that section was declared unconstitutional 3 or 4 years back, simply because we only have civil. We do not have criminal jurisdiction. We only have civil jurisdiction. Now, for you to come and prove that someone has infected you, then ideally you have to do what? You have to bring proof beyond reasonable doubt, which is under the purview of the criminal jurisdiction. However, for those who have been willfully infected, there's no hope lost, because when you look at Section 26 of the Sexual Offences Act, it actually specifically outlines that it actually provides for that, for willful infections, where it says that any person who willfully infects someone with HIV or any STI, then has committed an offense. So that one is now handled under the criminal purview under Section 26 of the Sexual Offences Act.
Very well.
I'm seeing another one from Duncan Dirangu.
Yeah.
Where he's asking on KDF's mandatory testing for HIV and negative status in order to join the KDF. We actually just issued a judgment last week against KDF regarding this, and so I can say that now that has been tackled, where we said it was unlawful for them to test or to test and to insist that for you to be enlisted as a recruit, then you have to be HIV negative. Since it was just yesterday, it was just the other day, I think that was on Friday, I am yet to see the appeal, but let us see how that pans out, because we are still creating jurisdiction.
There's a further question. So Duncan is asking, how about damages? Can the court award damages for willful infection?
We used to. That is when Section 24 of willful infection was still in force. But since that section was declared unconstitutional, we no longer handle issues of willful infections. So those ones are left for the criminal court to deal. So I can say for now we do not handle those ones. So we do not have jurisdiction, so we cannot handle it or even offer compensation for that.
Very well. As I'm about to bring up Mr. Mutuma, Ms. Mboku, please just take us through. I want to file a case at the tribunal. So how long can it take? How much can it roughly cost me, so that I can know how to bill my clients? Kila kitu ni pesa. So how much and how long?
Okay.
And do I need to come with an advocate? Am I just come alone?
Okay.
Yeah.
Thank you. Now, when I started, I said this is a human rights court. And so for matters money, I can assure you it is 0 rated. So there's no filing fees that is required for you to come to the HIV/AIDS, and for you to come to the HIV tribunal. Ideally, this being a tribunal, we are not as strict as the civil courts. An SMS can suffice, an email can suffice, a call to the tribunal can suffice. All you need to do is lodge a complaint, and then once the tribunal receives a complaint, then you're given a complaint form to fill. Then after that, the complaint form is given to you. If you do not have an advocate, then a pro bono advocate will be given to you. However, now that we are embracing technology, of course, we are now moving away from that, where it's now a requirement that you file your documents through the e-filing system. We are on e-filing, and ideally our forms are behind the act. So behind the rules. So should a client approach you and they want you to help with filing a complaint, then you can get the complaint form from there. You can get the complaint form from behind the act, and so you are able to upload it in the e-filing system. If not, then we encourage the complainants to actually access our offices physically, and we have a secretariat in Nairobi. And Apart from the Secretariat in Nairobi, we also have offices in all the former DCs, rather provincial officers' offices. The former PO, the former DC's offices. And where that is where in all the offices where NAC offices are, those are our satellite offices. They can also be assisted there. The complaints form are there. They'll be able to file them and send them to the tribunal, and then the tribunal is able to assist. That is for those who are not able to access the CTS. I mean the e-filing portal. As I said, it is zero-rated. We have partnered with pro bono advocates. There are several organizations that have been kind enough, especially those that handle human rights issues, and they give us advocates who come and take these pro bono. They come and take these briefs for free. So I can say right now we have almost 100 cases running, and all those cases, for those who do not have advocates, have been allocated pro bono advocates. What else was I supposed to answer?
I think that's the average time it takes.
Oh, the average time it takes. So ideally, whatever is provided for is 6 months, because all tribunals are supposed to have, that is from beginning to end, from the time when we receive the complaint to the time when we determine the complaint. It's supposed to take 6 months. There are those that take less, assuming you get summons and you come and file your responses within good time. Ideally within 4 months, your case will be, within 4 or 5 months, your case will be done. So we are playing with an average of 6 months. We do not have so many matters, as I said. Like right now, currently we have like around 100 cases running, but it's simply because it's a tribunal that is not yet known out here. So hopefully with time we will get busy, and then we will see how things turn out.
Very well, thank you so much. I think we'll bring in other questions as we move on.
Okay.
And members, please feel free to use the chat section to put in your questions, and the presenters will answer you. Mr. Mutuma, can you hear me?
Yes, I can hear you very, very clearly.
Yes, I want you to educate us a bit about how much would it cost me to approach the National Examination Appeals Tribunal? How long would that cost me? And do I need an advocate? And what are the rules? So how much, how long, what are the rules? And how much would it cost me? Do I need an advocate?
Okay, so let me start with the last two around length of time, because we can draw some quick comparisons with my two colleagues and the tribunals that they preside over. So you're in the context of exams, and we are in that period of January, February, and the pressure of timelines is quite heavy. Remember, these are situations where results have been nullified or cancelled. So there are two ways that you can approach the tribunal. One, of course, is directly. Any person who's aggrieved can come directly, or any institution for that matter can also approach us directly. Or you can go through the county director of education. Every county has a DE, and the residents of that county can go through that office. Now, if you go through that office, you have to have submitted some background noise, some vehicle behind me. The county director's office must then transmit to us that application within 5 days. However, if you're approaching the tribunal directly, it's anticipated that the institution or person should have submitted their complaint within 14 days of the decision of the Kenya National Examination Council. So you can see the timelines are very, very tight for obvious reasons. Now, the tribunal, upon getting that complaint lodged, also has very, very little leeway in terms of the decision making. So within 30 days, the tribunal should have determined the matter when it relates to primary school education and a complaint connected with that particular level. If it's a secondary school, then there is greater leeway, but still very tight timelines. The decision must be out within 60 days. So essentially, that is what you're looking at in terms of process. And we are strictly an appellate tribunal. So we're not handling matters of first instance. For obvious reasons, there is a lot of evidentiary issues when it comes to examinations. In fact, that is one of the constraints that the tribunal has. You can think about exams, you can think about questions of merit, you can think about challenges of standards when the marking was being done and so forth. So we don't, our jurisdiction does not anticipate those first instance issues. We are purely appellate. Now, there are prescribed forms like I had mentioned earlier. But I think it's important for us to view this tribunal through the eyes of public interest, questions about jurisdiction in the context of human rights and so forth. And I won't say that because I know you had prefaced your question in monetary terms, and is there opportunities, financial opportunities with the tribunal? I would want to say, cautiously and yet firmly, that they aren't for two reasons. The respondent in all these matters is the Kenya National Examination Council, and it will often use its own in-house counsel. At least that's what we've seen in the past. So they've got a group of legal officers that normally appear. The applicant, the appellant in these specific matters are not basically your individuals or your schools. And we do have a list of pro bono counsels that will assist them for different reasons. When it comes to cost, of course, the general ethos of a lot of these tribunals that are mandated by the Constitution and are seeking to present administrative solutions to challenges where commissions exist, councils exist. Our decisions do not incur any costs. So the outcome of the decision is not punitive in terms of that principle of cost following the event. And at the same time, because the tribunal is funded, there are no costs when it comes to the different modes of filing, both electronic and physical. I hope that gives you a quick overview. Sheila, and like I said, we are fairly new. We've been 6 months in existence. One of the major challenges that we are having, of course, is the question of funding. The tribunal came into play at a time when the state, the executive, and the exchequer has been squeezing budgets. This has been one challenge when it comes to the operations of the tribunal. Back to you again, Sheila.
Thank you so much, Mwalim. So apart from just the process of prosecuting at the examination appeals tribunal, perhaps, and maybe I didn't hear you on this, are there any rules of procedure, or is it like a free flow? I want to tie that with the question by Priscilla, and she's asking that where are the decisions of the tribunals stored? Can they be accessed by the public online?
Okay, so first let me start by saying, if you look at section 40K, it sort of, again, like many tribunals, emphasizes that the members are not to act with undue reference to technicalities. What that has meant is that we are cognizant of the rules of evidence, but we are not strictly bound by the same. Number two, we're also not rigid when it comes to procedure. Remember, a lot of the people who will be filing are just Kenyan citizens. They don't have a particular legal prowess or familiarity with procedure. And we simplify it very much. We simply say, present your case. What is the heart of your the complaint that you're bringing? Sum it up in the best way you can in a written form. We play a more almost like the civil traditions, civil law traditions, are more proactive role, not to lead or to guide applicants, complainants, but to help them put clearly what is the heart of the matter that they are seeking a determination for. So to that extent, you will not find the rigors that you have in civil procedure and so forth. There's another question that you asked. It slipped my mind because you asked about procedure, but you asked something else.
It's a question on where would the determinations by the tribunal be found?
Okay, so we are fairly new. So we haven't yet started compiling or putting together a compendium on the decisions. So at the moment, I think we are waiting to build, as you mentioned, you haven't said we've only been in existence for 6 months. So when we, of course, build a sizable chunk, I'm sure, and when we sort out our budgetary issues, and that is something alongside several other matters that our registrar of tribunal will assist us in putting together. But for now, those decisions, you would have to request them from our secretariat that is housed at the JSC. Thank you.
Very well. Thank you. So perhaps that it would be safe to assume that the tribunal is housed at the same JSC?
Yes. For the moment, that is the default position. And we are hoping it will not be like that for very long, and that we will be able to share with you our physical address sooner than later.
Very well. Thank you. Thank you so much. Again, I want to bring in Mr. Choi. Mahesh, I don't know whether you can hear me. Mr. Choi, can you hear me? You're on mute.
Sorry. I can hear you.
Yes.
Sorry, yes.
Please let us know how long if I want to approach the water tribunal, how long that would take me, and whether I can just come as an aggrieved person without going through an advocate, and maybe is there any cost I will incur, and are there any rules on how to bring a case or how to defend a case? Supposing I'm defending a case on behalf of maybe the water resources, are there any rules, or how do I do it?
Okay, thank you very much. So in terms of how long, just like my colleagues have said, the tribunals, the policies that in the tribunals, we are supposed to conclude cases within a period of 6 months. However, it may also depend on the nature of the case, but on average, within 6 months, a case should be concluded. And in that regard, also maybe let me also just talk about interlocutory applications in the tribunal. In our tribunal, you will find that in most cases, many cases are commenced by filing the claim alongside an application for injunction. Normally, you will find that the water service providers the water providers in their agreement with the tenants, or I mean the users, the consumers of water, they have they normally have this clause that if there is an payment, maybe for a certain period, they will disconnect water. So in most cases, you will find that the water service providers, when maybe the bills are not paid in time, or there is a dispute, they will normally walk into somebody's premises and then disconnect water. So many parties normally come to court with these certificates that they want the water reconnected. And our tribunal, you'll find, I think it is a unique one in the sense that you will find that in most cases where there are these applications for where water has been connected, and there's an application, a mandatory injunction application for reconnection of water, you will find that in most cases the tribunal issues these orders at the first instance. And this is, of course, because of the provision in the Constitution about, water is a basic human right, provision of water. And therefore, normally when those applications come, you'll find that we issue those orders, water is reconnected, and then we can deal now with the issues. So this way also, it helps in fast tracking the case. Because we avoid a lot of litigation around the applications, because in an ordinary application, parties will take time to maybe the respondent to file a reply, further affidavits, submissions, and all that. So by the time you deal with an interlocutory application, about 1.5 months or 2. That time you would rather have it in just hearing the matter and having it disposed of. So I within 6 months, as I'd said, then you'll find that many matters are finalized within 6 months. Now, as to whether someone can just walk in and file a matter and the issue of representation, I've seen that in most cases that are filed in the tribunal, you find parties are represented by advocates. But that is not to say that an individual cannot file a matter without representation. Someone can file without representation, and we have support services in our secretariat. I think I've shared in the wall our email address, and also the telephone number of our contact person. So anytime, even if it is an individual without an advocate, or whether it is an advocate who has maybe an issue or an inquiry they want to find out, we can always be reached on the contacts that I have shared. In terms of costs, we normally use the court fees assessment schedule. That is the judiciary court fees assessment schedule, and that schedule provides for filing fees for litigants in the tribunals. So, and in the tribunals, I think the litigation fees, the filing fees is normally not very high. I think it is very affordable. And just if I can look at a glance from that schedule, you can see for unliquidated plaint or claim, on unliquidated claims, the filing fees is as low as, I think it is 1,000 shillings. Filing bundle of documents is a bundle of documents in support, I think is just around 300. So it is not very expensive. The filing fees, in my view, I think are affordable. I think I saw some question. Let me see whether you can help me, Effie, with some questions I've seen.
There are two questions.
In the chat, yes.
There are two, perhaps three.
Mm-hmm.
The first one is where are the decisions of the tribunals found? Where can they be found?
Yes.
The number two,
yes.
Duncan is asking, considering the magnitude of water disputes and cases within the country, and this being a tribunal, how many cases have been filed from 30th December 2023 to date? That's number one. Considering the magnitude of water disputes and cases within the country, and this being a tribunal, how many cases have been filed from 30th December to date? Then the second question is, does the tribunal visit different counties or towns and or cities to determine matters, or does it only sit in Nairobi?
Okay. The first question on where the decisions of the tribunal can be found. Our decisions are normally published with the Kenya law. So if you check the Kenya law, you will find our decisions are published. And every decision that we do is always uploaded in our portal, the CTS portal. But they are also published at the Kenya law, so they are available there. The next question was on the number of cases, the magnitude of the cases. I agree that this is a tribunal that can actually attract quite a number of cases. So as I had indicated earlier, I think the only reason we do not have so many matters at the moment is it is because, as I had said, there was a period of, I think, about 7 years. The tribunal was not sitting, and now the litigants, many litigants, even who had at that time, when the tribunal stopped sitting during the transition period, there were about 900 cases countrywide that were pending. You can imagine for 7 years, you have your matters in court, nothing is going on. So what happened is that some of the parties managed to move their cases to these other courts so that at least they can have a hearing. Many of them, I think, they lost hope. There are matters actually which were just left pending, so that when we came over, when we took over from the Water Appeals Board, we had about we had about 600. Yeah, actually about 600 cases that were pending with the Water Appeals Board previously. So what we did, we gave them new numbers. We published, we did a notice. We did a notice that the tribunal has taken over the matters, and we published it with the Kenya law, and we had all these matters mentioned. But what we found is that many of them actually had been settled. We wrote to the law firms that were dealing with these matters. We contacted them, but we found that many of them had been settled in one way or another. Just about 10 or 15, okay, not more than 20 matters were still pending. But even them, when we now started the process of hearing, we found that there were issues that actually could no longer be addressed by the tribunal. From December 2023 to date, the number of cases that have been filed are not so many. I think they are not more than 60. The new matters now between December 2023 to date. In fact, maybe more than half of those were filed last month. And I believe the reason basically is that we need to do a lot of sensitization so that, you know, many people are not aware that this tribunal actually is existing. And we are aware that once we do proper sensitization, we are likely to have quite a number of cases. Regarding whether we visit other towns, the Water Appeals Board actually had about we had offices. We had offices in the former 8 provinces. So each province had a water tribunal office where cases could be filed, and then the board or the tribunal used to have a circuit, so that we used to have a circuit. At one time, the officers were to visit the courts in different times. In Kisumu, there was an office. There was another office in Mombasa. I know that there is an office in Kitui. There is an office in Nakuru, in Nyeri. So we have those offices in different towns, even now. But you know, now with the e-filing, it is a bit different. Sometimes we don't even have to. We don't even have to do the circuits, because if we file the matters in the system and we do them virtually, then we avoid movement to some of these towns. However, where there are cases or there is need, or we find that there is need to have a physical court, maybe in any of these towns, then we normally make arrangements for the same. As I had indicated, there is a bill actually in Parliament, and we hope that soon we are going to have members joining in, so that you know, it would be easier and services would be a bit faster. So I think that is what I can say for now.
Very well.
Yeah.
I don't know whether you have answered whether you visit different towns.
Yeah, I've just said that is what I've just said, that at the moment, I think there's no need to visit the towns, because we hear these matters virtually. So once someone has filed their case, we mention the matters virtually, then we give directions. If we find that there is need to visit these towns or conduct matters from the various towns where we have our offices, then we do that. But most cases are normally handled virtually nowadays.
Very well.
Thank you.
So in finishing, I think I just have two main points. I'd like to bring a final round. I'll begin with Ms. Mboku. My first concern would be, why would I approach the tribunal and not court? And then number two, are there opportunities for advocates in terms of new areas of practice, or can they offer themselves for pro bono, or what can advocates do to collaborate with the tribunal?
Okay.
Those two questions.
Okay. Why the HIV and AIDS Tribunal? As I began by stating the composition of the board, and you can see that we have advocates, we have doctors, and we have two professionals. So ideally, when you bring your matters before the HIV and AIDS Tribunal, that matter is going to be handled by professionals who are people who have experience in the area of human rights. And so this is, you'll rarely get this in other courts, because even our appeals, it's only the judge will sit alone. He'll not be assisted by a doctor. He'll not be assisted by a professional in the human rights field. And so there are one or two things that the judge might not get that we at the tribunal are likely to get. So we are looking at expertise. As I said, most tribunals, our turnaround time is 6 months. And so we're also looking at saving time. So ideally, you bring a matter to the tribunal, you will within 6 months, you have your judgment. Then we're also looking at the cost implication. Prosecuting a matter at the tribunal is free, and you're also given a pro bono advocate for free. So why would you want to go and file a petition in the High Court and pay, I don't know how much petitions cost, maybe 6,000, 10,000, depending on the prayers you're seeking as an initial cost, and the other additional costs for filing fees. But at the tribunal, you will be heard, and your matters will be determined for free. Not a single cent will be spent. Then for opportunities in the tribunal for advocates, for those advocates who have a passion for human rights, I think this is the only court, in the tribunal that handles human rights. And so it could be a great place to start as a pro bono advocate, where you come, you get files and try to get some experience in that field. That is by offering your pro bono services. You can offer to do research. So researchers are also welcome. But because of the nature of cases that we handle, they are sensitive. You will have to sign an MOU with us, such that whatever information you come across shall not be shared to the public. As I said, the issue of disclosure is something that is very serious. So we look at that. I have just seen a pop-up. Message asking me whether we are a circuit. Unfortunately, we are not a circuit. We are not a circuit tribunal per se, because of the number, because we don't have so many files. But what we do, as I mentioned before, we have eight satellite offices in all the former provincial headquarters. And so when need arises, and then we usually go down, especially where the matters that assuming we have matters for children in a particular area. Let's say it is it's the area around Nyanza or the area around Western. We are likely, depending on the numbers, we can make a trip. But otherwise, our sittings are virtual. But filings can be done in any of the satellite offices. I think I think that's it.
Yeah, I think that is it. So is there an email or would we, if we need to register for the pro bono,
Yeah.
do we use the email you have shared on the chat session?
Yes, yes. You can just send an email, or even you can also send an SMS. As I said, for us, you can approach us by whatever means, and then someone will get in touch with you. Just say that you are interested in joining the pro bono scheme, and an MOU will be sent to you.
Very well. I think that's been really helpful.
Thank you.
Thank you too. Mr. Kenneth Wyne.
Yes, yes.
Mwalimu, as we finish up, please just tell us why would I approach the Education Appeals Tribunal as opposed to going direct to court? And whether, I know you said it's just a startup, so you do not have so many matters, but would there be an opportunity for advocates to learn and offer their expertise to the tribunal?
I think I would echo what my colleague Carol has said. Cost is obviously the greatest incentive, because when you go to court, you must be thinking now with deep pockets for various reasons. And this is why you find the tribunals very convenient, in the spirit of the Constitution and access to justice. So this is the first point that favors coming to the National Education Appeals Tribunal. The other is much in the spirit of what we are seeing right now on the streets, in the social media, that there is a role for advocates to play when it comes to supporting matters within the public interest. And you know, education is one of those matters, particularly exams. And I would strongly encourage our good colleagues, not necessarily because it pays well, but because you will be doing a valuable service to so many schools and individuals that are out there who have a legitimate claim or cause, but they will prosecute it in a poor manner. That you learn the years of investment and expertise that you have in supporting those parties as they present and they seek to bring a claim before the tribunal. I would also encourage you to get in touch with us if you are interested in providing some pro bono services in that regard. The experience that you will acquire will be enormous. And for me, I don't believe there's anything for free. Eventually, the kind of things that happen, you end up being retained for different causes. I think your name, of course, you know, the school community is very large when you think about Kenya. That's where you could find yourself getting work completely unrelated because you stood out for many of these schools. I've seen also the comments from my colleague Duncan asking about that kindly comment on the outcome of the case we observed early this year in the midst of the KCSE results, in which there was a case of a school candidate getting D grade and D minus. Okay, yeah, the irregularity of the results. There were a few of those cases that came before us. And of course, one of the things that we look at is not just outcome, but also process. And this is the whole reason for our existence. The only limitation we have, Bonadankan, is that we look at not individual cases, but large scale complaints that come from entire ecosystems, either institutions, schools, or a large group of students. The way we've been set up, we don't as it were, approach the question of merit, looking at whether how the results were, the exam scripts were marked and so forth. But we look at irregularities like this ones, where you have, for want of a better expression, students all getting either being downgraded and being then nullified, cancelled. And we did get a few of those cases, and we gave a determination in relation to them, particularly from this past 2023 results. Thank you very much, Dr.
Thank you to Mr. Kenneth Wyne. Last but not least, and I see Duncan is uploading the session and your remarks. Allow me to now bring in Mr. Choi. Mr. Choi, please just join issues with your colleagues on why tribunal, what are tribunal as opposed to court, and what are the opportunities for us to come and learn and give our time and expertise.
Okay, thank you, Effie. On why tribunal, I just actually, as you said, I'll just join issues. My colleagues, tribunals, cases in the tribunals are faster. As we have said, our turnaround time is around 6 months. For the water tribunal, as I had indicated, I think there's even an incentive that once you have been instructed by your client, an application for a mandatory injunction to reconnect water, you will always get that one without a lot of sweat. You earn your fees. But basically, anyway, we are quite we are faster. The rules, our rules also are not very strict, so we are very flexible, and that way our matters actually are moving quite fast. Of course, also, as we had said earlier, the costs of filing matters in the tribunals are quite affordable. In regard to opportunities, I think for us, what I can just say is that we do offer places for students, law students, for attachment. So that is how we can assist. We offer places for attachment for students who are learning law throughout the year. So students, you normally apply to the registrar tribunals, and they will always indicate which tribunal has got vacancies, but those ones are always there. Maybe an area we would want maybe more collaboration with the advocates is just to make even our systems even more effective, to request that when we are filing our matters, we ensure that we label and mark our documents well, so that when we go for the hearings, when we start the matters, we do not have a situation, those situations that we normally see in the other courts, in the non-ordinary courts, where parties now have again to ask for time, a lot of time to file other documents. The other side also to file other documents. So if all of us are careful when we are filing documents, I think it helps in disposal of the matters fast. I think that is all I can say, and thanks for having us.
Thank you very much, Mr. Choi. I think members, we have all learned a lot today, and we've also learned about the opportunities that are available for us. All the details have been typed on the chat section. Please take the number, take the email, note it down somewhere, and let us reach out and learn as we also prepare to earn. I'll do just a minute of getting a final word from all the presenters. I'll start in the order in which we have gone. You can say your final remarks so that we can also hand it back to the Secretariat and finish the meeting. So, Ms. Mboku.
Okay. So mine is just to thank everyone who has joined today. I hope and believe that we were worth of your time, and just to encourage you to come and practice in the tribunals. There's so many opportunities there. So I'm looking forward to seeing new faces there and seeing you join the pro bono scheme. Thank you so much. Have a nice evening.
Thank you too so much. Have a nice evening, Ms. Mboku. I'll go to Mr. Kenneth Mutuma.
Yeah, I want to thank our esteemed colleagues for giving us audience. We truly appreciate. I would encourage them to think about practice in a very, very novel way. You are the minds and the brains of the country, and you can see how you have been able to help the cause of the country in the present circumstances that we've been experiencing. That should not be confined there. I think everywhere we are seeing, I mean, the word that they're using is occupy. But there's so much of a need for you to occupy, quote unquote, many areas where you can actually support processes for the benefit of the public interest. And education is one of them. While initially it might look like it's not lucrative from a financial point of view, I think you will find it has major returns in your development as a person and the opportunities that will pop up because of that. So I encourage you to come and serve and lend your expertise to many schools, particularly when you are getting to around February, March period when the exams start to come out, January, February. And March. Thank you again, Madam Moderator, and our good colleagues that are on the panel. And thank you very much to also our esteemed audience.
Thank you so much, Mr. Mutuma. Last but not least, I'll bring in Mr. Choi and a round of final remarks.
Thank you very much, Effie, and all participants for having us. We are grateful for giving us this opportunity to sensitize advocates, colleagues about the tribunals and what we do. We hope that we have been worth your time, and I hope that you will give us even more time so that we may be able to share whatever we have, and also even for us also to learn from you and understand maybe the challenges that are faced out there, so that we may be able to address them when we have the opportunity. Otherwise, thank you very much. And we look forward to other engagements in future. We also hope that our colleagues will help in sensitizing even members of LSK, even from other regions. So thank you very much. Back to you, Effie.
Thank you so much, Mr. Choi. Thank you, a rich panel of chairs, for gracing us with your presence today and taking us through the various tribunals. I think it has been insightful. Your willingness to share information and share the numbers and share the emails is something that we do not take for granted. I hope many colleagues can register to offer ourselves to better our society by offering our expertise. We also thank our members who made time this afternoon to just join us and engage the panelists. this would not have been successful without you guys, and I'm really thankful that you guys made time. Thank you to the Secretariat, also LSK Nairobi branch, for making this happen. Asanteni sana. And I hope that you can maybe get the numbers shared on the chat session and the emails and just circulate to our other members who didn't create time to join us today, to also consider offering themselves to serve the public in these tribunals. My name is Efi Sheila Chieng. I'm a council member, Nairobi branch. I'm glad to be your host today. It has been quite a learning session as well. And I'm really happy to always learn from our seniors. So this marks the end of the Know Your Tribunal session for today. Until another time, God bless you guys. May the Lord keep you, and thank you so much.
Thank you. Goodbye.
Thank you, presenters. Thank you, everybody. Such an insightful meeting.